Good morning, everyone, and I'd like to welcome you to today's webinar. I'd like to extend our welcome to our Compass Private Wealth clients and our professional referrals. Today's webinar is on succession planning. As you are aware, Compass is running a series of webinars throughout 2021. To date, we have reviewed the investment market, retirement funding, protection. Today, our focus is on succession planning, and we will provide an update on macroeconomic update in May. We'll be sending out our May invitations later in due course. Today, we are joined by Jonathan Sheehan, Managing Director of Compass Private Wealth, and also Kent Carty, Partner and Solicitor of Kent Carty Solicitors. Before I pass you over to both Jonathan and Cormac, I'll just run through our standard housekeeping rules. So questions can be submitted throughout the webinar by clicking on the questions tab and just submitting your questions. The webinar itself will be recorded and slides will be made available once the webinar is completed. Without further ado, I'll pass you over to Jonathan to kickstart our webinar.
Thank you very much, Angela, and thank you to Kent Carty for agreeing to be our guest speaker at this month's webinar. So before we speak about the specifics of succession planning, let's look at it, the context of financial planning. It's only one pillar in the big picture. The first thing we'd look at always is retirement planning, succession planning, which is what we're speaking about today, cash flow planning. Again, this is related to both of the above. Asset allocation, so how your assets are invested. Investment selection, so within the asset allocation framework, how your specific assets are going to be invested in what types of securities, level of risk, asset allocation, all that type of thing. Always to make sure that every financial decision you make is tax efficient and that your costs are minimized. Risk management, so that's downside protection. We would have covered that in our protection webinar last month. And also just general financial education. So really, financial planning is about putting all of these 8 pillars together, and I trust me that you can never look at any one of these areas in isolation. You always have to look at the big picture. So, why are we speaking about succession planning? Well, firstly, it's relevant for you no matter how old you are. The older somebody is, it becomes a bit more relevant, but no matter what stage of life you are, succession planning is always fundamentally important. So the first reason is to ensure that your assets are passed on according to your wishes. Simple as that. You also want to avoid unnecessary and avoidable taxes, and we will speak about the tax rates in Ireland for both gift tax during your lifetime and inheritance tax on death. Asset allocation, which I'll speak about shortly, is about making sure that your assets, your pensions, your cash, your property, your investment portfolios, whatever they may be, are correctly categorized according to your time horizon. Also, you want to avoid complex issues for whoever your personal representatives or executors are administering your estate in due course. So making sure that your affairs are as simplified as possible. There's also, for those with larger amounts of assets or for professional advisors here on this webinar who are advising clients, I suppose there is an element of education for both children and potentially grandchildren to make sure that they understand the investment strategy, they understand your assets, they understand the tax implications. And this could be for a husband or a wife who may predecease their spouse, to make sure that the other spouse is equally up to speed on the overall entirety of the assets and what the overall strategy is. And most importantly, to put yourself in the mindset of financial freedom when you do actually write your will and you put your succession plan in place. Now, in my experience, having worked with UK providers before and with UK clients, if I were to compare the succession planning industry in the UK versus, say, Ireland, I would say the UK is actually light years ahead of Ireland, purely because they have wealth intergenerationally for hundreds of years. Whereas in Ireland, actually, the passing of assets from one generation to the next is a relatively new concept. So it's something that a lot of clients of ours we're working very hard to educate them as to don't just look at your lifetime, also look about your legacy and the intergenerational passing of assets. In that regard, there's 3 life stages in relation to financial planning and in relation to succession planning. There's everything up to now. So if you're 50, if you're 60, if you're 70, if you're 80, whatever that may be, you can't change the past. So you have your assets up until this point. You have the rest of your life. So however many years, I always just use 90 as a target, age 90 for an individual or a couple, and work back from that. So protecting the value of your assets between now and then, and ultimately after you. So the next generation or the next generation even after that, to make sure, frankly, that their legacy is commensurate with your financial affairs. Now, everybody's estate plan and succession plan is specific to them. But I suppose consistent to everybody is that there are 2 certainties in life, death and taxes and all that. So for anybody who has dependents or descendants or may not have descendants but have other people that they want to pass assets on to, there always will be a passing of assets somewhere. So with succession planning, and this is, in my view, the most important slide, and myself and Cormac, we're doing all our dry runs and conversations in relation to this. There's 4 different, I suppose, types of wealth as such, and I'm just looking at monetary terms here. So from 1 down to 4. So I suppose those who have worked their entire lifetime to get up to the second or the first rung, in our experience, it's usually they want the next generation to remain at that level. And in one way, while one is working and while one is being entrepreneurial and building an asset base, they can actually move from 4, 3, 2, 1 quite seamlessly in a lot of ways. But the difficult thing is actually staying at the level you want it to be at. And ultimately, the Irish government will take 1/3 of your estate in tax. There's investment markets carry risk. There's any number of reasons why somebody could move from 1 to 2 or 2 to 3 or whatever it may be. So succession planning and financial planning generally is about putting a target in place as to where you want to be and staying at that level for your generation and the next generation. So 4 aspects of succession planning. So if somebody comes to me to talk about a pension, I can put on my pension planning, pension advisory hat on, and that'll be all that's important. I will advise them in relation to their pension. If someone goes to a tax advisor and asks for tax advice, they can just give tax advice. With succession planning, you can't get standalone advice from any one professional advisor, because in my opinion, there's 4 different sides to it. The first is asset allocation. So it's looking at all of your assets and saying, what assets do I need for me and my spouse in our lifetime, and what assets are for the next generation, and how all that's done. And we'll talk about, bare trusts and small gift exemptions in Section 72 and Section 73 and all that in the asset allocation section. The second side of it is obviously the legal side, and that's why we've asked Cormac to speak to you today, to speak about wills, enduring powers of attorney, all that type of thing. The third side of it is tax. So neither Compass nor Kent Carty provide tax advice. So you do also need tax advice in relation to your estate. So there's 3 professional advisors as such you kind of need. And the 4th one is behavioural. And there's no professional advisor like Compass or like Kent Carty or like a tax advisor who actually can coach or advise you on behavioural, because we can give you all the advice from a tax and legal and investment risk and asset allocation, show you lovely pie charts and all that type of thing. But ultimately, it's your decision, or if you're a professional advisor on this webinar, it'll be your client's decision, and we can only provide you with the tools and then the facts and the data and the charts and the cash flow projections and all that type of thing. But ultimately, it's up to you. So I might say to somebody, it makes sense for you to give, for a couple to give 6,000 per annum in small gifts to every single individual below them in the family chain, but that may not be something they want to do. So it's just important to consider that as well. Asset allocation. Okay, so before planning for the next generation, you need to make sure that you have sufficient funds for yourself first and foremost. So most people will only have sufficient funds for themselves for their lifetime. So a couple will have an asset base that they will need for their retirement, to enjoy their retirement. If you have surplus, then you can look at additional funds for the next generation. So I suppose this slide is only relevant for those who would have assets that are surplus to the requirements for their lifetime. So what do? You calculate the estimated capital value of your assets, you deduct your lifetime requirement, and the remainder equals capital for the next generation. Now, this is as simple a calculation as possible. Obviously, clients of ours on the call who've been through this exercise with us, there's a lot more to it than that. It depends on your age, it depends on the value of your assets, it depends on your ARF distributions, depends on the state pension, depends on all these other things, your cash flow, surplus or deficit. But that's ultimately, in really, really simple terms, what the calculation is. The mistakes that people make when it comes to asset allocation is that 9 times out of 10, clients underestimate or they overestimate the value of their estate versus what they need for retirement. So somebody says, I want to retire at 65, and I say to them, well, your chances are you're going to live until, one of the two of you and a couple will live until after 90. So can you really afford 25 years of not earning money and funding your lifestyle? So actually, you can retire at 65, but you can't spend as much as you think, and you definitely will have nothing left over. Whereas we have other people who have enjoyed very strong asset growth over the years, and they actually have more than enough money that they need, and they should actually start ring fencing that for succession planning now at an earlier age. So 9 times out of 10 people under or overestimate the value of their assets. Another big bugbear is people come to me and say, well, I've got a pension, what should I do? And I would say, well, you need to look at all of your assets holistically. The pension is only one part of the big picture. If you're married, a husband and wife should look at their assets collectively, and don't differentiate between a pension and your personal cash or your personal investments, whatever it is. Look at it all holistically, and clients of ours know that that's always something that we're trying to encourage clients to do. Assets are not profiled and categorized in terms of risk, so the level of risk holistically doesn't match what their appetite for risk to risk is, tolerance of risk, and capacity for risk. But also short to medium term assets. So a couple saying this is the amount of cash we need for the next 10 years, but we have surplus money that will definitely be for the next generation. Then would it not make sense for the money you definitely need to have that in low risk liquid assets like cash or on post or whatever it might be, and then money for the next generation? You can say, well, we have a 30-year plus time horizon on that, so let's ring fence that and put that fully into equities, or allocate money to Section 72, Section 73, bear trusts, all that type of thing, small gift exemptions. And individuals and couples don't know what their annual cash flow position is. Again, genuinely, this is something that we help all of our clients with. These are the common mistakes. You can never look at succession planning or any other area of financial planning in isolation. You always have to look at the big picture. So I'll now pass over to Cormac Carty to speak about the legal aspects, wills, enduring powers of attorney, and probate.
Thanks, Jonathan. I'm not sure if my video has come up there. But what I'll do is I'll just start anyway. Oh, hang on. There I am. Okay, well, thanks, Jonathan, and thanks for inviting me to talk at the seminar today. By way of introduction, my name is Cormac Carty. I'm a partner in Kent Carty Solicitors, specializing in wills and probate matters. And today we're going to talk about some of the legal aspects of succession planning. So we'll start off by just posing the question why you should have a will. Well, the first obvious thing is that if you don't have your will, your intentions of what happens to your estate after you pass away may not be met. In a scenario where there is no will, what's known as the rules of intestacy will be applied. So what are the rules of intestacy? Well, basically they say that if you die with a spouse and no children, everything goes to your spouse. If you die with a spouse and with children, 2/3 goes to your spouse, 1/3 goes to your children. If you've more than one children, it gets divided equally amongst them. If you die without a spouse or without children, it goes to your parents. If your parents have already passed away, it goes to brothers and sisters. If some of those brothers and sisters have died leaving their own children, well, then their share goes down to their children, and it goes on and on down the chain like that. So whilst that scenario might suit some people, it probably won't suit most of the people. And the simple solution is to put things beyond out by just writing your own will. So what is a will? Well, I've just put up a definition on the screen there of what a will is. A will is the expression of a person's intentions, normally concerning the distribution of his or her property, which he or she intends to take effect after his or her death. Some of the formal requirements are the testator has to be over 18, has to be of sound disposing mind. He's got to sign the will at the bottom, and he also has to sign in front of 2 witnesses who also sign the will. The will itself speaks from death, so it's only relevant to the assets of the testator as at the date of his death, not before. And then another thing to remember is that if you do make a will and then you get married a couple of years later, well, then your will is revoked by the subsequent marriage, so you need to make a new will. A lot of the times the clients that would come into us, they would simply, they might be husband and wife, and they might say, look, we just want to leave everything to each other, and then if one of us when we both pass away, we want everything to go to our children in equal shares. So what I've done is I've just put up a sample will on the screen there. This is for a husband where he's leaving everything to his wife. He appoints his wife as his executrix as well. And if his wife predeceases him, well, then everything goes to his children in equal shares. And you can appoint the children as the executors as well in that scenario. So what are some of the things that you need to consider if you are making your will? Well, if you're married and you're writing your will, your spouse is entitled to what's known as a legal right share in your estate. What this means is that if there are no children, your spouse is entitled to half of your estate, or if there are children, your spouse is entitled to 1/3 of your estate. So if you make a will and you're leaving less than half or 1/3, as the case may be, your spouse can then elect to take their legal right share in your estate. It's also important as well for couples that are separated to remember that they're still spouses in the eyes of the law. So in any kind of judicial separation or separation agreement that you might enter into, you would want to be careful that you have renounced that legal right share so that the spouse can't come back and take a chunk of your estate after you pass away. When it comes to children, there's no automatic legal right the same way that there is for spouses. However, there is what's known as a moral duty on the testator to make proper provision for the child in accordance with his or her means. So if a testator, for example, he's got 3 children and he decides to leave his estate to only 2 of them, the 3rd child could bring an application to court under section 117 of the Succession Act 1965 so that or seeking that proper provision is made for him. The court would consider the application from the point of view of a just and prudent parent, and it'll bear in mind a number of factors such as the age and prospects in life of the child, his or her mental capacity, any gifts that have been made during the testator's lifetime, such as transfers of property, monetary gifts, or an expensive education. So it's just something to think about when you're writing your will. If one child is going to get more or less than the other, you would probably need to think about if there's a good and sufficient reason for doing so, and what are the likely chances of the child, for instance, who's gotten less than the others, maybe trying to contest the will and bringing an application to get a greater share in the will. People sometimes ask us then as well, what happens if one of my children predeceases me? What happens to their share? Well, you can make provision for such a scenario in your will by saying that their share will go to somebody else, or it'll go to their children if they have any. If you don't make any provision in your will, their share, it could fall into the residue clause, or if the predeceased child has children of his own at the date of your death, well, then their share will take effect as if they died the day after you, and there's specific rules under the Succession Act on that. A lot of people that would come to us would be making wills. They might have children under the age of 18, so they have minor children, and they'd be concerned that their kids are taken care of in circumstances where, for instance, both their parents have passed away. So, for instance, if there was a car accident or something like that. Well, what you can do here is include a trust clause in your will to say that the estate will be held in trust for the benefit of the children until they reach a certain age. You need to appoint trustees, usually 2 trustees, and they'd hold the assets in trust for the maintenance, welfare and education of the children. In order to avoid discretionary trust tax implications arising, such a trust would usually come to an end when the youngest of the children has reached the age of 21 or completed full-time education. At that point, any funds that are left in the trust will be released to the children in accordance with the testator's wishes. So for instance, if he says in equal shares, well then each child gets an equal share in the residue left in the fund. I mentioned at the start some of the pitfalls in not creating a will, chiefly that the intentions of the testator might not be met. So the simple solution is just to make your own will. The next slide is on enduring powers of attorney. So people probably heard of the enduring power of attorney, but they mightn't know exactly what it is. Well, an enduring power of attorney enables you to choose a person called an attorney to manage your property and affairs in the event of your becoming mentally incapable of doing so. When clients come in to us to make their wills, we would usually ask them if they'd also like to create an enduring power of attorney. And this touches on a point that's going to be mentioned as well, that, as a society, people are living longer. And unfortunately, this means that the chances of people encountering mental capacity issues such as dementia become greater. So there's more and more people coming into us to create enduring powers of attorney. And if you decide to create an enduring power of attorney, the first thing you need to think about is who your attorneys are going to be. Most people appoint 2 attorneys, or else they might have 1 attorney and 1 substitute attorney in case the first attorney is not able to act. You also have to appoint 2 notice parties. The notice parties, they act as a kind of a safety net, because if the attorneys want to go ahead and register the enduring power of attorney, giving them power of attorney over your affairs, they'd have to give notice to the notice parties, and the notice parties have the opportunity of objecting. For example, if they think that there's nothing wrong with you and there's no reason for the power of attorney to be registered. And one thing to remember as well is if you're married, your spouse has to be one of the attorneys or one of the notice parties too. In terms of powers that you give to your attorneys, you can give them a general power in relation to all of your property and affairs. And if you do so, the attorneys can do most things as if they were you, such as deal with your money or property. I might be able to sell your house, for instance. And if you don't want your attorney to have such wide powers, you can include any restrictions that you like. So for example, you could include a restriction to say that your attorney can't sell your house, or that they can't withdraw money from a certain bank account or something like that. And you can authorize your attorney to take personal care decisions on your behalf. For example, where you should live, with whom you should live, what your diet should be. And you could also include provision to say that a certain person has to be consulted in order to gauge what your best interests are. What's not included in the powers is the power to make decisions with regard to medical treatment. This will be covered in the Assisted Decision-Making Capacity Act, which has yet to come into force. And when it does, it'll replace the existing system with regard to enduring powers of attorney. Also to mention is that you need to get a certificate from a doctor both before you create the enduring power of attorney to say that you have capacities to do so. And then also when the attorneys are seeking to have it registered to say that it is actually time to register the enduring power of attorney. And just moving on to the next slide then, this has to do with probate and executors. So what is probate? Well, after somebody dies, we'd usually be contacted by the spouse or the executor, and they'd ask us what happens now for the purposes of administering the estate. We usually set up a meeting with the executor. We read down through the will and see what the wishes of the testator are. We'd ask the testator what the assets in the estate are, and they might tell us, for instance, there's a family home, there's a few bank accounts, and maybe a pension or a life policy. And if those assets are in the sole name of the deceased, well, you'll need to extract a grant of probate to have the legal ownership in those assets vested in the executor, so that the executor can then pass on the relevant shares to the beneficiaries. Sometimes the assets might be in joint names with his or her spouse. in which case they would usually pass by way of survivorship. So there mightn't actually be a need to take out a grant of probate. But a lot of the times you'll need to take out a grant, especially if, for instance, the first parent has already passed away and there's a surviving parent left. In terms of taking out the grant, well, the executor has to file a number of forms with revenue and also with probate, setting out what all of the assets and liabilities in the estate are. And he has to give an estimate of what the value of the net estate is. And he also has to give an estimate of how much each beneficiary is going to receive. And once the grant issues, then it usually takes about maybe 2 or 3 months for the grant to issue. This is the legal document that is needed to actually gather in the assets. So, for example, a copy of the grant is then sent off to the bank, and you ask the bank to release the funds. So then the bank send on the funds in the bank accounts, and they're held in the estate account. Or, for example, if you want to sell a family home, well, you'll need to have the grant of probate before you can actually complete the sale of the property. And when it comes to beneficiaries, I mentioned that when the forms are filed, with the Revenue Office and the Probate Office, you also have to give an estimate of how much each beneficiary is going to receive. So, for example, if you've got an estate worth 1.5 million, there's 3 kids, each kid is going to be receiving 500,000 euros. Revenue now know about this, it's on their radar, and they know that Revenue are now going to be thinking, okay, how much tax are we going to get? And also how soon are we going to get it, and when do they have to pay it by? So this brings us on to the next slide to do with capital acquisitions tax. And I think Jonathan's just going to briefly go through the taxes, and then I'll pick it up from there.
Thank you, Cormac. So in terms of tax implications, so this is obviously a very important part of succession planning, because ultimately the current CAT rate in Ireland is 33%, which obviously isn't insignificant. So 33%. Now, the difference between gift tax and inheritance tax is gift tax is a lifetime passing of assets, and inheritance is on death, but the rate is the same, the 33%. There's 3 thresholds. There's Group A, which is parent to child, Group B, brother, sister, and all that, and then Group C would be anybody other. So, for example, the spouse of your child will be Group C, your nephew or your niece would be Group B, and that type of thing. So the first 335,000 a child inherits from their parent is tax-free, and anything above that is 33%. Importantly, if anybody has children or grandchildren, in some cases, living outside of Ireland, that doesn't escape the charge to Irish CAT, because if the donor, as in the person who dies, the person given the assets, is resident in Ireland, there's 33% tax liable here, even if the other person, the beneficiary, the child, say, is in Australia or in the UK or something like that. So I'll just hand back to Cormac here to speak about CAT payment dates, valuations in relation to probate.
Yeah, just one other thing, obviously, is spouses and civil partners don't pay any tax. That's probably an obvious point. So in terms of the payment dates, if you do have to pay CAT, the next thing you're going to be thinking about is, when do you have to pay this by? It's usually the 31st of October in the year that the grant of probate issues, or it could be the 31st of October in the following year if the grant issues after the 1st of September. So as you can see, timing can be quite important, especially if you need to liquidate a few assets in order to have enough funds to discharge your CAT by the relevant due date. This is sometimes why people might put off administering an estate, as they don't think they might have enough cash to pay the CAT. Having said that, though, one word of warning is that if the asset significantly increases from the date of death to the date of sale of the asset, for instance, well, then the executor might have to pay CGT on any gain that arises. So just to give you an example, if somebody passes away and the house is worth 500,000 euros when that person passes away, the executor then goes to sell it, and it doesn't sell for another year, and it sells for 600,000, for instance, there's going to be a notional gain of 100,000 euros, which the executor will become liable to pay CGT on at a rate of 33%. And so I think that that probably wraps up this slide, Jonathan, if you want to
Thank you.
move on to
Thank you very
planning.
much for that, Cormac. Yeah.
Yeah.
So in relation to planning opportunities to minimise tax, ultimately, the one we all know about is a small gift exemption, which is €3,000 can be gifted each year tax-free to any third party. Now, that seems like a very small amount of money, but just for an example, if you had a couple who have 3 children who are all married and 6 grandchildren, that's actually 12 descendants below them. And because each of the husband and wife can give 3,000 to each of them, 36,000 by 2 is 72,000. So if you said, okay, well, I'll give 72,000 to these 12 beneficiaries this year and next year and the other year, every time you do that, you're saving 24,000 in tax. So again, this is only relevant for those who've surplus assets in excess of what they need to enjoy their retirement. Remember what we said earlier on, you need to look after yourself first. But if you have surplus assets, it absolutely makes sense to do this. Now, again, going back to what I said earlier, a tax advisor or a financial planner like me or a solicitor like Cormac will tell you this makes sense, but sometimes people decide not to implement it for different behavioural reasons, and it's important to recognise that as well. One way of we find useful from a behavioural point of view is rather than a couple in their 60s or 70s writing a cheque of 6,000 to every child and every child's spouse and all the grandkids, a better way to do it is actually to set up a series of investment accounts that can all be done at once. And any of the children under 18, you can set up a simple bear trust, which is a simple investment policy, and it's a bear trust that vests in their name when they turn 18. And in that way, the beneficiary isn't just receiving a handout of 6,000 and say, oh great, I'm going to spend all that. It goes directly into an investment account on their behalf, and it actually gets invested with a long-term strategy, so it ticks the asset allocation box as well. And obviously the individual beneficiary knows about it, but at the same time, in all likeliness, they wouldn't actually draw it down, or the gift could be given anecdotally on condition that they don't just encash the investment. Another planning opportunity, is family partnerships. These are really, really useful for a certain type of client because it's a way of gifting assets to the next generation, but maintaining control. Speak to me or Cormac afterwards about this. We don't have time to go through it in too much detail, but ultimately the partnership can be seeded with cash to cap out, say, the Group A thresholds, or if you're bringing grandchildren into it, the Group B thresholds. But what's unique about a partnership is that it's transparent for tax purposes, but the donors, i.e. the people putting money into the partnership, which would be generally the parents in their 60s or 70s, they maintain the voting shares, but the beneficiaries maintain the equity. So it's very, very clever. The partnership then every year can receive a small gift exemption every year. So it's a way of getting around giving the 6,000 to them directly. And the partnership, actually, you set up a bank account with EIB or Bank of Ireland or whatever it is, and that's the current account of the partnership. It has an IBAN and you can invest it. We invest a lot of family partnerships, just looks like any other portfolio, and all the children, everybody can be involved in the investment decision making. So it's a very clever tool. Again, as you know, these slides will be available afterwards, so I won't talk about this in too much detail. Section 72 whole of life policy is an insurance policy that an individual or couple can take out for the entirety of their life, and the proceeds of the insurance policy are tax-free as long as they're used to pay inheritance tax. So this can be extremely tax efficient. The only caveat is that you do have to do medical, and people over the age of maybe 72, 73, it may not be appropriate for them at that stage because an insurance company would look for a reason not to insure them. But anybody from kind of 55 up to 70, can be highly tax efficient. An alternative for somebody who doesn't want a life insurance policy is a Section 73 savings policy. This is, in my mind, the best product out there for minimizing capital taxes. It's a regular premium investment policy. You set up in your name. You have the option without the obligation of using it for gift tax to minimize gift tax purposes. You have to commit to it for 8 years. And the policy value can be given to a third-party beneficiary to cover gift tax in the same 12-month period after 8 years There's a lot of planning issues that come with these that we can't touch on today. But if they're relevant for you, they can be extremely relevant, if that makes sense. So ultimately, these two policies, as well as the small gift exemption, are all about reducing the 33% CAT rate. What I'd say in summary, and we've had a couple of questions come in, so keep typing in the questions. The four summary points I'd make is, firstly, when looking at a succession plan, don't speak to a solicitor like Cormac or whoever it might be, or a tax advisor and us, but you need to look at the asset allocation first and foremost, and look at all of your assets, your cash flows, and ultimately know what the value of your assets are, what you need in your lifetime, and what's going to be for the next generation. Put your legal aspects in order. Wills, enduring powers of attorney. Everybody should have an enduring power of attorney, certainly over the age of 60 or 65. You want to minimize intergenerational capital erosion through tax planning, Section 72, Section 73, small gift exemption. As we know, when myself and Cormac had the slides earlier in the week, we actually had mentioned dwelling house exemption, but as a lot of people know, that benefit is pretty much gone now. But you need to decide yourself what you want to do with your affairs. So again, we can tell you all the technical points, but ultimately it's up to you to decide, and your spouse, what you want with your assets. So with a case study here, if you could just have a quick look at this case study, and then Cormac and myself will just discuss it. So let's just say a couple, John and Mary, they're mid-60s, and we estimate they live until 90, that's the default age. Let's say they have 3 children, 2 of whom are married, 1 of whom is single. There's 4 grandchildren. There's ultimately 9 descendants, not dependents, but descendants below them in the family tree. The value of their assets, let's say it's 7 million. There's a family home, they have investment properties. They've got ARFs, approved retirement funds, they've got cash. They may have life policies and different things, but let's just say for round figures, it's 7 million. And the red box will tell you how much tax they would pay. So you're paying nearly 2 million in tax without tax planning, so 7 million goes to 5 million. And that's a very, very big chunk. I don't call it tax planning, I call it intergenerational erosion of assets, okay? So this is why it's so important to review this. 33%, okay, 1.95 million tax on 7 million is a lot of money. So it does need to be looked at.
Yeah, and there's a lot of avoidable tax, Jonathan, as you say there as well.
Exactly. So I think what I'll do now is I'm going to take the screen off. These are the 4 areas of it, and Cormac myself will speak about this case study and just have a general discussion about, I suppose, about tax planning generally, or succession planning generally. So Cormac, in relation to the legal aspects of a case like this, what do you think would be the most important things for a couple like that? Should they just set up a default will each to each other and then split everything 3 ways, or what other things should they be looking out for?
Well, they can certainly do that, and that's what a lot of people generally would do. They would make their wills, leave everything to each other, and then leave it to their children in equal shares. But as we were kind of saying, there's other ways of that will leave people open to tax, and there is ways of reducing their tax. There's a couple of beneficiaries. I mean, instead of the parents giving everything to all the kids, they could make gifts to the spouses of those kids if they were minded to do so. They could also make gifts to the grandchildren, up to 32,500. The spouses would be strangers, so that would only be 16,250, I think. And then at the same time, if there is cash, I can't remember, is there cash? Yeah, there's 1 million in cash in that case study. There's no reason you couldn't start setting up your trust accounts for the small gift exemptions to start moving, for instance, money to the grandkids. And so, I mean, there's 2 parents. There's 9 descendants in total. So 2 by 9 is 18. 18 by 3 is my maths isn't great. Is that 54,000? So there is ways of kind of moving cash before the time comes. I mean, if they live to their 90, there's another 25 years, and 25 years of making those payments it's a lot of tax savings if you start to do that, now. So, I mean, they're just the very kind of obvious things that people can do. And it's good that people kind of know what those taxes are so that they can know there's ways of avoiding them if possible.
And I suppose one of the technical things with pensions and tax, which any tax advisors on the call will know, but we've obviously moved from defined benefit pensions 20, 30 years ago to nearly all defined contribution pensions now. And the default product for pre-retirement pension is an approved retirement fund or an ARF. Yeah. The value of your ARF doesn't count towards the group thresholds. They're outside of inheritance tax, and it's a flat 30% rate. So when you're calculating the tax due on your estate, the value of the ARF will firstly go to your spouse tax-free, but on the latter demise, it's taxed on a flat 30%. But the Section 72 policy does actually cover the ARF tax, so it's a small technical thing. Yeah. Cormac, what happens if a 50-year-old and a 50-year-old couple do their will and they select a sibling as their executor, and the sibling is the similar age, yeah. And 30 years later, that same sibling is still an executor, and let's say that executor has died, or they're no longer suitable or appropriate to be the executor. What happens on demise of the executor? And this is one of the questions we've come in, has actually died already, or if that executor themselves is no longer fit and capable to administer an estate.
Well, I mean, it's a good consideration when you are picking your executors, maybe to choose wisely, and if possible, I mean, a lot of people would choose their spouse to be the executor, and that's absolutely fine. Usually when one spouse passes away, the surviving spouse might say, okay, maybe it's time to make a new will. And in that scenario, they should be thinking about appointing an executor in the generation below, because for obvious reasons, you don't want your executor to pass away, which can happen. In a scenario like that, somebody else would basically just have to step in and become the executor, but they would be known as the administrator rather than the executor. And you just have to tailor your application for a grant in those scenarios. And the person that would be entitled would be, the closest family member, and it would kind of go down the chain, because it would have to be like, if it's a sibling who's passed away, well then, and there's nobody else, there's no other executives who are alive, well then it goes, you'd look to the children and see if they want to act. And assuming one of them does, well then they would then be the executor or the administrator, as the case would be.
Yeah, I think that's very important. And, going back to the four different aspects of it, I think that everybody really should have a holistic succession plan in place. And, one of the questions we have here is, what happens with illiquid assets? So let's say, for example, somebody dies and they have an equity portfolio or a pension fund, and I can tell you as of the valuation at that exact date what the mark-to-market valuation is. But if it's a business or it's a commercial or residential property, yeah, how much, what can people on this webinar, clients of ours, or what can they do now to ease the process of valuing the assets, of making sure that the executors don't get into hot water revenue for assigning the wrong value to it? How does it work with, there's 4 kids and 2 of them are executors, and what happens to the other 2 kids? I'm throwing a lot of questions at you here now, Cormac, but yeah. Should the children attend the meeting with you as a solicitor when the couple are writing their will, or should they recuse themselves from that, or what are the kind of inter-family political implications?
Well, there's plenty of those. Trust me, anytime there's a will, there's a good chance that there might be a bit of a dispute. But in terms of like who's in charge, the executor's in charge. That's why they're appointed executor, because they're usually like the person who the testator thinks is the most responsible one and will carry out their wishes. And that's why it's very important when you're choosing somebody, you choose somebody who is responsible and is going to do the right thing. Usually all beneficiaries would be entitled to see a will anyway. to assess what they're going to be getting. For the most part, executors and beneficiaries are very transparent, and it's good to be transparent so that there's no mistrust, because that can certainly occur amongst family members. But the more transparency, the better. When it comes to stuff like that.
One thing I'll say as well, it's a question here actually from one of the attendees, is about loans. So a lot of our clients would be in the position where their children are, say, in their 20s or their 30s, and compared to previous generations, even a really successful professional in their early to mid 30s, in particular where we live, Cormac and Dublin, it's very difficult to get on a housing ladder because central bank rules with 3.5 times earnings and the deposit and that type of thing. So it is possible for parents to loan money to their children, okay? And that loan itself obviously isn't a gift, but it needs to be very, very carefully documented between the parents and the child. And again, Compass, while I'm tax qualified, we don't give formal tax advice, but you'd assign a rate of interest, that which can actually be very generous at the moment, given where interest rates are. And that's one of the beauties of the family partnership as well, where parents can loan money to the family partnership itself can loan money out. But if through mymortgages.ie, my brother Joey in Cork, who we work with on the mortgage side for our clients' children generally, it's very difficult sometimes to come up with the funds, because if parents loan money to the child, the banks won't count that as your deposit as such. So if your children do want to buy a house, and for a certain amount that's in excess of the central bank, you may actually be better gifting a portion of it as an irrevocable gift under the Group A threshold, and then also maybe loaning some and potentially loaning some from the bank as well. Yeah,
it's certainly something to think about. If you do gift some money to your kids, obviously it'll go towards that Group A threshold that we talked about of €335,000. If some of it is made by way of a loan, it's important that it's documented correctly, so that it's not seen to be a gift when it's actually a loan. And the other thing is that it's important to recite a rate of interest in that loan, because if you put it down as a interest-free loan, well, then it might have adverse tax implications as well. So it is important to record it in writing, and also to include the relevant rate of interest as well.
And the last point just on that, if you have a property and your children are one or some of your children are living in it, and you're letting them live there rent free, well, if the market rent is 20 grand a year, that's technically a gift from you to child of 20 grand a year. So what you can do is you can offset some of that against a small gift exemption in that.
Absolutely. Yeah, you could.
Cormac, Carty, thank you very much. That's really, really useful. We've had so many questions that have come in that we haven't had a chance to answer. Please do follow up with us.
What we could try to look at them and get back on any of those questions if we can.
A small plug for Cormac as well. They do property conveyancing as well, and I sold and bought not too long ago, and Cormac handles everything very professionally. And so if you need a will or conveyancing property, he's a good guy. So thank you everybody for joining us today. We'll be in touch with the slides. If you have time to fill out our feedback form, that would be great. We'll also send the recording of this as well, so you can watch it back if you missed any parts, or pass on to anybody else. Thank you very much, everybody. We'll speak to you soon.